Hello, my name is Chris Trulianti, and I'll be presenting this webinar topic to you today. I'm a master's student in the Safety Science Department at Indiana University of Pennsylvania. I am also a graduate assistant in the department. The topic of this webinar today is medical marijuana and implications of Pennsylvania workers. This webinar will be presented in PowerPoint fashion with a question and answer. You may ask questions through the Zoom chat feature. If I cannot answer the questions during the webinar, then the answer will be posted on our website within 7 days of the webinar. So I think most people definitely know what marijuana is or medical marijuana is and the effects of it. I don't think it's necessary to go in a complete synopsis or history and explanation of what it is. I do believe in a thorough education of whatever you're trying to deal with, but the point of this webinar is more towards how to handle it in the workplace. So I'm going to give some brief information on what medical marijuana is. The bulk of the webinar will be about Pennsylvania policies, court cases on medical marijuana in the workplace, and how to handle it in the workplace. The topic is still very new, and there is no one perfect way to handle the issue, but the information that I'm about to present to you is open to interpretation. The most important part would be to stay active and be on the lookout for new information regarding medical marijuana in the workplace. So, what is medical marijuana? The term medical marijuana refers to the using the whole unprocessed marijuana plant or its basic extracts to treat symptoms of illness and other conditions. The FDA has not approved marijuana as a safe and effective drug for any indication. Scheduling is a classification of drugs based on abuse potential, medical use, physiological dependence. Here's the chart on the slide. There are 5 schedules for control, C1 to C5, and they're presented in decreasing abuse potential order. Each schedule has different manufacturing, distribution, and prescribing controls. The aim of scheduling is to ensure medical availability while reducing abuse and diversion. There are different penalties associated with various schedules. Governor Wolf legalized medical marijuana in Pennsylvania on April 6, 2016 with Act 16. February 15, 2018 is when it became available for patients at dispensaries across Pennsylvania. Patients with serious medical conditions can apply for medical marijuana card. Serious health conditions means an illness, injury, impairment, or physical or mental condition that involves any period of incapacity or treatment connected with inpatient care, which means like an overnight stay in a hospital, hospice, or residential medical care facility, or a period of incapacity of more than 3 consecutive full calendar days from work, school, or other regular daily activities that also involves continuing treatment by a healthcare provider twice or once with a continuing regimen of treatment, or any period of incapacity related to pregnancy or for prenatal care, or any period of incapacity or treatment for chronic serious health condition, period of incapacity for permanent or long-term conditions for which treatment may not be effective, any period of incapacity to receive multiple treatments, including recovery from those treatments for restorative surgery or for a condition which would likely result in incapacity of more than 3 consecutive full calendar days when medical treatment, days absent medical treatment. So that would be like chemotherapy, physical therapy, dialysis, or etc. On this slide, these are different types of medical conditions that are covered for medical marijuana. Act 16 also defines the forms of medical marijuana that can be distributed by the dispensaries. These forms are pills, oils, topical forms, vaporization, tincture. Tincture is kind of like a liquid. It's kind of high concentrated. It comes in like drops. You might be able to put it in your eye. I'm not exactly sure. Patients that take the topical form don't have the same side effects as the other forms due to the inability to penetrate the bloodstream. My mom has a medical card. She usually uses the cream for neuropathy. I can tell you, like, from firsthand that she does not present like any of the normal, like, the high symptoms of being confused or just like lazy. Like, that's not related to that whatsoever. The other forms definitely give off the side effects. As of right now, I don't think that there's edibles allowed in Pennsylvania. My mom told me that she thinks that they're going to happen, or at least coming across dispensaries sooner or later. I know in other states there are edibles. In the case that edibles become widely available for the medical marijuana users, side effects usually take like hour and a half, and that's usually because of digestion. It takes a little bit to get into the bloodstream. All the other forms are really easy to get in the bloodstream. So some side effects of using medical marijuana include headaches, dry mouth, dry eyes, lightheadedness, dizziness, drowsiness, fatigue, nausea, paranoid thinking, disconnected state, increased appetite, coughs. It's important to note that these side effects vary from individual. Also, the amount taken can affect how severe the effects are. These side effects are what you may want to look for when you suspect someone for being under the influence on the job site. These side effects aren't good enough alone to terminate someone, though. So, instance, like if someone's coughing a lot, it may be associated with medical marijuana, but then again, they might just have like a throat issue. So you couldn't just say like, all right, I'm going to terminate your contract just because they're coughing a lot or they're feeling dizzy. It's something important to note and keep track of. I'll talk about like record keeping later, but just you should probably learn the side effects of what medical marijuana is and keep it in your back pocket. So here's a map of the United States that shows what states have comprehensive medical marijuana programs and the states that have low THC programs. As of August 1st, 2019, there are 33 states that have comprehensive medical marijuana programs and 13 states with low THC programs. The National Conference of State Legislatures defines a comprehensive program as protection from criminal penalties for using marijuana for medical purpose, access to marijuana through home cultivation dispensaries, or some other system that is likely to be implemented. It allows a variety of strains or products, including those with more than low THC. Also, either smoking or vaporization of some kind of marijuana products, plant material, or extract. Not limited trial program. So South Dakota and Nebraska have limited trial programs that are not open to the public. The point of this, of me like showing you the map of the United States, is to highlight the fact that medical marijuana is everywhere you go in the United States. This means that this will be a factor in the workplace wherever you establish a business. As more and more people acquire medical marijuana card, having a zero tolerance for medical marijuana may or may not be the best practice based on the types of tasks that the job must perform. So if you think that you can, I don't know, move your business to some other state just to not deal with like the whole medical marijuana issue, you're going to eventually have to. So it's better to establish a protocol, some program, some policies to deal with the issue in general. Throughout the country, there has been court cases that have dealt with medical marijuana in the workplace. Most of the cases were decided in favor of the employer. Recently, there have been a few court cases that sided with the employee. It seems like more things are becoming more progressive. But I'm about to explain some examples that were in favor of the employer. So Ross versus Raging Wire Telecommunications. On September 7, 2005, the Court of Appeal for the Third Appellate District issued a published decision denying a qualified medical marijuana patient any remedy for terminating from his or her employment simply for testing positive for marijuana. And Ross versus Raging Wire Telecommunications. The court relied on federal law to defeat Gary Ross state law causes of action for wrongful termination and violation of public policy, and employment discrimination in violation of California's Fair Employment and Housing Act. After many appeals on January 24th, 2008, and a 5-2 opinion, the California Supreme Court narrowly construed the Compassionate Use Act to rule in favor of the employer and hold that medical marijuana patients cannot state civil causes of action for employment discrimination. The next case, Emerald Steel Fabricators versus Bureau of Labor and Industry. The employer discharged an individual after he disclosed that he was a registered user of medical marijuana. The Oregon Supreme Court held that the employer did not act unlawfully in terminating the employee, holding that because federal law prohibited the use of cannabis and the employer discharged the employee for engaging in illegal activity, the Oregon disability statute did not apply. Next case, Coates versus Dish Network. The Colorado Supreme Court held that although the use of medical marijuana was lawful under state law, an employer could terminate the employee who uses medical marijuana because it was still unlawful to do so in federal law. So the theme of most of these court cases were the fact that since the FDA says, no, it's not legal, we don't like it, and all the court cases just basically side with that. Even if the states said that they are allowed to use it, no. That's just how the court cases were being decided. But then the new court cases have been deciding in other ways. So the first court case, Barbudo versus Advantage Sales and Marketing in Massachusetts. Massachusetts court denied the employer's motion to dismiss and held that the employer should have engaged in an interactive process with the employee rather than terminating her when it learned that there was a medical marijuana user. And then the next case, Chance versus Kraft Heinz Food Company. This is in Delaware. Chance had a post-accident drug test. He failed the drug test, but provided a valid medical card. There was no proof that he was under the influence at the time of the accident, but the company terminated his employment. He filed suit alleging violations against the anti-discrimination clause contained in the Delaware Medical Marijuana Act, or DMMA. Delaware court noted that the Controlled Substance Act does not make it illegal to employ someone who uses marijuana, nor does it implicate to regulate employment matters. The CSA prohibits the unauthorized manufacture, dissemination, dispensing, and possession of marijuana. The CSA was not in conflict with the DMMA. CSA is the Controlled Substance Act. The DMMA states employer may not discriminate against a person in hiring, termination, or any term or condition of employment if the discriminate against a person in hiring, termination, or any term or condition of employment if the discrimination is based upon a person's status as a cardholder or a registered qualifying patient positive drug test for marijuana, unless the patient used, possessed, or was impaired by a marijuana on the premises of the place of employment or during the hours of employment. The Delaware court found support in prior decisions of the Rhode Island and Connecticut courts. So now they're more siding with what the state says, and if there's like a program, they usually have some sort of discrimination clause, and they will take that over the FDA. Pennsylvania, actually, they had a marijuana court case, but it wasn't medical. A guy claimed, well, he was on medical marijuana. He did get terminated after. He wasn't on medical marijuana. He was on marijuana. He was tested after the accident. He said that he was using the marijuana as medical treatment, but it wasn't. He didn't have a medical card. He was using it illegally. So the courts didn't side with him. That's the closest thing that Pennsylvania has to a court case, but that doesn't hold up with us. It's important to note that they found decisions of Rhode Island and Connecticut to help them. That's because like Delaware, they didn't have a court case that dealt with medical marijuana in the workplace. So the courts are going to look towards neighboring states to see what they did. And all those states are in relative vicinity to Pennsylvania. So what these court cases are citing will probably be what Pennsylvania will decide. So don't rely on the FDA saying that it's illegal. So you may be asking, why do these court cases matter? Again, the court cases use other court cases decisions to help them make their own decision. The language in the Delaware discrimination clause and the PA discrimination clause are very similar. Sorry. You can compare them right now. It is likely that Pennsylvania is confronted with the issue. It will look towards Delaware for guidance. Again, please compare these two. They're almost word for word. They're pretty close. So it doesn't, and also there's no like accommodation with this. I think one of the court cases said it should have worked towards the employee, which to me sounded like an accommodation. On our Pennsylvania Act, it says that we don't need to accommodate, but I believe that there should be some sort of accommodation to show that you're trying to work towards it. That may not mean, oh yeah, smoke on the premise. I don't really regard that as a good practice. But I don't know, working with the patient would probably, or not the patient, your employer or employee would be the best way. For employers, you should be paying close attention to these court cases, watching why the courts decided the way that they did, what the employers do that the court cases went against. A policy that mandates termination for a positive drug test with no exception for legal off-duty medical marijuana use used to work, but these new court case decisions are considering that discriminatory. The traditional argument that a positive drug test for marijuana can result in termination because marijuana remains illegal under federal law is not the recommended way to handle this. But based on previous court cases, that argument would be likely refuted. Steps that employers should take would be establishing a drug-free workplace, make policies and job-specific tasks related to safety-sensitive duties and public health, establish a way of tracking job performance, so if someone is underperforming, you may be able to relate it to marijuana use. Also, there should be an action plan established when you find out one of your employees is a medical marijuana user. Here is a sample template for a drug-free workplace policy. This template is provided by a drug-free workplace. They're a grant-funded program dedicated to helping businesses create and implement drug-free workplace programs. All of their services are free, and I emphasize free, very important. They have a policy builder where you can use this template or create your own based on your industry. They provide a workplace education, employee assistance, and family education. They have information about drug testing also. They're an extremely valuable resources for businesses in Pennsylvania, and I highly recommend using them. I also highly recommend using this template. It is laid out very thoroughly and covers all bases. So if your company doesn't even have like a program, please use this or look for it to guidance. I went through one of their medical marijuana training sessions, policy webinar things. I thought it was very thorough. They're very good. They know what they're talking about. They allowed me to spread some word, allowed me to use their template to show you guys. Again, it's free. It's hard to come by free services. And I just flat out say you guys should be using this and paying attention. Give them a call, ask questions. So what makes a great policy is having all your bases covered, having proper training about medical marijuana for your management employees is a great step to take. Training on the hazards associated with being under the influence during work, what to look for when someone is under the influence, and how to handle a situation when an employee is under the influence would suffice. Providing access to those employees that have drug issues would also help. This doesn't mean that you need to pay for them to handle their drug struggles, but having information on file for them to use, like the local drug rehab center, This would show your employees that you care about their well-being and that you're not just out to discipline those under the influence. Clear parameters about drug use should be presented in the policy. There have been some companies that allow the use of medical marijuana on the property, and like I said before, I do not think this is the best practice. But it is up to the discretion of the employer. You could possibly allow off-site use of medical marijuana during breaks, which are off the clock. These 2 points would be considered accommodations to those medical marijuana users. Pennsylvania medical marijuana clearly states that no employer must make any accommodations of the use of medical marijuana on the property or premise of any place of employment. With that way the court cases are going, that may change, but you can not restrict medical marijuana users from using it at home, since that is deemed off the clock and they are not engaged in illegal use. Clear rules for post-accident drug testing should be addressed also. There are many options for drug testing. Under the Pennsylvania Medical Marijuana Act, it highlights what medical marijuana users can't do while under the influence. And this is coming straight out of the act I'm about to present to you. The following prohibition shall apply. A patient may not operate or be in physical control of any of the following while under the influence with blood content of more than 10 nanograms of active tetracannabis per milliliter of blood in serum. Chemicals which require a permit issued by the federal government or state government or any agency of the federal government or a state government. High voltage electricity or any other public utility. The patient may not perform any employment duties at heights or in confined spaces, including but not limited to mining while under the influence of medical marijuana. The patient may be prohibited by employer from performing any task which the employer deems life-threatening to either the employee or any of the employees of the employer while under the influence of medical marijuana. The prohibition of shall not be deemed an adverse employment decision, even if the prohibition results in financial harm for the patient. The patient may be prohibited by any employer from performing any duty which could result in public health or safety risk while under the influence of medical marijuana. The prohibition shall not be deemed an adverse employment decision, even if the prohibition shall result in financial harm for the patient. I would like to know that there is no sampling technique for marijuana that gives immediate results on the spot. So knowing that the employee has 10 nanograms of active tetrahydrocannabis per milliliter of blood in serum will be hard to prove on the job site. I did read an article about a breathalyzer that could be used to give immediate readings, but those are not readily available. Safety-sensitive position is a job or position where the employee holding the position has responsibility for his or own or other people's safety. Also, the position includes duties or responsibilities that involve the supervision, custody, or care of children or youth. To make a job safety-sensitive, an employer must be able to demonstrate that the employee's inability or impaired ability to perform job-related tasks could result in direct threat to their safety and or safety of others. It is easy for a transportation company to prove that the driver is in a safety-sensitive position because if he or she is under the influence while driving, he or she could cause harm to him or herself and others by crashing the vehicle. Other jobs may be hard to prove, but trying to create tasks that involve sensitive material like handling private information or interacting with others on a regular basis may be the answer. The safety-sensitive designation can provide a layer of protection against negligent employment practices claims. When an employee injures a coworker, customer, or member of the public and then tests positive for medical marijuana or even a legally prescribed opioid, an employer can find themselves facing a claim for negligent employment practices. When an occupation is designated as safety sensitive, you may have more latitude to ask questions about drug use and test more frequently. These questions and testing can help you maintain a safer work environment and protect you better from liability. When an occupation is designated as safety sensitive, inquires regarding whether an employee is currently taking any prescription drugs or medications, whether the employee has taken any such drugs or medications in the past, or monitoring an employee's taking of such drugs or medications are permissible. It may also require a blood, urine, and breath analysis to check for alcohol use, as well as tests to determine the current illegal use of drugs. Under Title I of the ADA, an employer's ability to make disability-related inquiries or require medical examinations is analyzed in 3 stages: pre-offer, post-offer, and employment. At the pre-offer stage, which is prior to an offer of employment, the ADA prohibits disability-related inquiries and medical examinations, even if they are related to the job. At the post-offer stage, which is after an applicant is given a conditional job offer, but before starting work, an employer may make a disability-related inquiries and conduct medical examinations, regardless of whether they are related to the job, as long as it does so for all entering employees in the same job category. At the employment stage, which is after the employment begins, an employer may make disability-related inquiries and require medical examinations only if they are job-related and consistent with business necessity. When conducting the pre-employment screening, do not ask if they're medical marijuana card holders. It's kind of like the same thing about like asking what they identify as like their gender. You can't ask like about like prescriptions at the beginning too. It's along those lines. What will allow an employer to discipline an employee is if the employee is under the influence and their performance falls below the normal standard of what is acceptable. This is pertaining to someone who has a medical card and not someone who is using marijuana illegally. Obviously, if someone's using it illegally, you can just terminate them. So if someone is under the influence and they cause an accident, could be a reason to discipline the employee, the accident being the reason. Another way could be that they are under the influence and their performance is chronically under the acceptable level. Again, chronically, this isn't something that might happen once. You need to have establish a way to document and prove that their performance is declining. Tracking job performance may be a little tricky. Just saying that the employee is not performing their job to an acceptable level without any documentation would not hold up in your argument to discipline an employee under the influence. When first hiring the employee, make sure that there are clear and concise job duties and tasks established and document that the employee understands and agrees with what is accepted. There are different ways to track job performance. Performance reviews may take too long and don't give real-time performance indications. Just watching your employees could work, but you probably don't have time to watch them work all day and there's no documentation of what's going on. Asking the employees to create deadlines for project plans, checklists, and regular weekly reports could be one way to have documentation of performance. Weekly reviews of the work being carried out by the employees could also work. There are also online programs that are made to help businesses organize projects being worked on. I just Googled some programs, and one program that came up is Basecamp. I looked into it. It has ways to customize every project, organize project information, daily activity emails, agendas of daily tasks, notifications that keep employees on task. It is worth looking into programs that help organize productivity in your workplace and not just for monitoring for employees under the influence. I have no experience with this software, but I'm giving an example to help investigative performance tracking software. I'm not promoting Basecamp. I have no clue if it's even good. I did read some reviews. Everybody says that they love it. But in general, I hope that you just like look into a different way, or at least give it a thought on different ways to track job performance, because it will definitely help your argument if you come into this issue. When you have an accident in the workplace involving a worker that is under the influence and is a medical marijuana user, what is your next step? If you can prove that the employee was under the influence during the time of the accident, then you could possibly have grounds to terminate them. You could also have a talk with them about what happened. Sometimes I think that we act too fast, letting the employee give their side of the story and provide why they were under the influence at the time could give some light on the subject. They could have not realized how long the effects of their marijuana treatment were going to last. It happened to last into their working hours. You could put them on probation period at work to see if they're improving. Remember, most people don't try to cause accidents or incidents that cause harm to others. Human error is inevitable. You need to have an action plan written in your policies. Also, you can't treat one medical marijuana user one way and another user another. Keep things consistent with every medical marijuana incident. I just want to highlight the fact that, again, a lot of people, I would say most people, really don't try to cause accidents that cause harm to others. I don't think, again, to highlight again, we don't communicate very well with the workers. I mean, honestly, like everybody, like I said before, when they take their treatment, sometimes it lasts longer than others. It depends what they ate. If they slept really good the night before, it might have hit them a little bit harder this day. Yeah, it's just, sometimes I think we just act too fast. You definitely need to give them some credit and then see what was actually going on and address the issue head on with them. And here are the most common drug testing options for marijuana. It gives other drugs on the side too. Well, I used to have a different graphic, but this is just all like related to medical marijuana. Saliva is somewhat unreliable, but the quickest to perform. Urine is the most common method of drug testing in the workplace and is cost effective. Hair is the most accurate and it's hard to skew, but it is expensive. Blood is also very accurate and hard to skew. It is less expensive than hair testing, but still more expensive than urine. Urine and saliva testing can be skewed if administered at a work site. If you contract out to a lab, it is harder for the employee to cheat the test, but it's still possible. I've had to take a drug test for an internship that I had with a physical therapy place. Had to go to a lab, and I feel like other people have definitely taken tests. But they had the door open with me, and I think someone was watching me, sort of, at least from the back. And they first asked me to pee into the toilet for like 3 seconds and then into the cup. And this is the reason, is in what first comes out is like a little concentration, and I guess like the hearty concentration is in the midstream when you're excreting urine. Also, the way to check, and if you're doing this on the premise, is how hot the urine is. Sometimes if they're cheating the system, they might bring in some fake urine and just have it in a bag under their pants or something, and then put it in the cup. I've also seen an apparatus where it's exactly like the body part down there. They put it on. It comes with manufactured urine that also has a heat pack with it. I mean, it's amazing what lengths these people go to skew their results. But the best practice I would recommend is go out to a lab. Don't conduct it in the work site. So here are my references, and also I just want to bring some key notes to you guys, is that definitely pay attention to the news. Keep your eyes out on different court cases that are that are going on. Again, as of right now, I don't think there's any court cases. Someone told me that there might be one coming out very, very soon. So if it is, keep an eye out for it. Again, record keeping is very important. Just keep track of everything. If you notice something, just mark it down one day. Have like an employee file for each person, and note it. And then same thing with the job performance. That's probably going to be your best bet if something happens. If they're chronically underperforming, you definitely have a court case that you can fight with. And you can't rely on the fact that it's that the FDA views the subject as illegal. That's not been holding up, especially in our part of the country. So again, create policies that really help out, use the drug-free workplace template, and then contract out to a lab if you need a drug test. Here's the PA OSHA consultation website. This is where we'll be posting the answers. Here are the numbers. And the next webinar will be on ergonomics, January 15th, 2020, 10:30 a.m. I appreciate you attending my webinar. I put a lot of work in this, and I'm proud of the result I have, and I've definitely learned a lot, and I hope I made everybody else learn a lot. So, yeah, thank you.